So good afternoon, everybody. I'm Andy Rich. I'm Dean of the Colin Powell School, which is the School of Social Sciences here at City College. And I want to welcome you to Courting Justice, LGBTQ Protections, Daca, Reproductive Rights, and the Path Forward for Social Progress. The Supreme Court finished its term last week, a little later than normal, with a number of consequential decisions. The three that are our focus today were among the most important that relate to the extension of rights in this nation. In the LGBTQ rights decision on June 15th, the Supreme Court extended the protections of the 1964 Civil Rights Act to protect gay, lesbian, and transgender employees from discrimination based on sex. In the June 18th Daca decision, the Supreme Court denied the Trump administration's program to end that program, or its approach to trying to end that program, at least in the way it was trying to do it. And then on June 22nd, the Supreme Court struck down a Louisiana law that sought to impose an undue burden on women seeking abortions. All three decisions are victories for rights activists, but the cases are very different in their scope, and the decisions are very different in their implications for long-term change. Today, we're joined by three experts and advocates, leaders who were involved in fighting for rights on each of these fronts. I'm going to introduce them in just a minute. We'll discuss the cases, we'll discuss their implications for the law, and even more, we'll talk about the consequences for the kind of movement building and activism that is so essential for social progress. All three of our speakers are lawyers, but you don't have to be a lawyer to be a leader in this space. And as we will discuss, the mechanisms of the legal system are only one of many important venues for social justice leaders who are organizing for change. As we begin, I want to introduce CCNY's President Vince Boudreau. His office is co-sponsoring today's event with us. This is the, by my count, 6th Zoom event that the Colin Powell School has hosted since May. Several of them have been co-sponsored with the president. We typically don't do events in the summer, but this is not a typical summer. So these discussions have been an important and I think a timely way for us to bring our community together, and they've expanded our community in ways that have brought many of you to us in ways that perhaps you couldn't if we did events on campus. So I thank you all for being here. And with that, let me turn it over to President Boudreau.
Well, thank you, Andy, and thank you for the work that you've done and the Colin School has done to put these events on. I want to start where Andy ended, which is to acknowledge how extraordinary it is in the middle of July to be producing and hosting roundtables and seminars as the Colin Powell School, some with us, some on their own, been doing all summer long. And you know, a couple of reasons for that. And the first, of course, is in this moment of COVID-19, the aftermath of the George Floyd murder. You know, the university has an obligation to make its resources, its good offices available for these broad conversations. We're living in a time when, you know, the conflict over the protection of rights, in part, I think, because so much has changed, has really distilled down as institution after institution tasked with the maintenance of the rule of law, due process, the protection of rights. As these institutions have failed to take the stands that we've expected of them in the past, the conversation does kind of settle into a conversation where the courts are now a leading voice. And so I'm very much looking forward to this conversation on that front. But even taking that out of consideration, if you think about the rapidity with which over the last 8-10 months, conversations about the scope of rights, the protection of rights, billions of rights against political tides that are not inclined to protect rights has advanced. This is an extraordinary moment. And I think that's the other part of why we're here in the middle of the summer, that as an institute, City College, I know as a school, the Colin Powell School, we're not neutral on the question of the protection of LGBTQ rights or the right of immigrants or the rights of people under in how we police society and all the other rights. These are not neutral questions to us. And we work in a community, we serve constituencies. We are motivated by worldviews that take the side of the protection of, the expansion of the rights that protect the interests and prospects of served communities. We recognize, and recognize more deeply now in the wake of the pandemic than ever before, that there is an intersectionality to disparities in healthcare, disparities in access to education, disparities in the protection that rights give communities. And so for all these reasons, we have had in the past and will deepen in the future the inclination of our institution to say that we have a specific set of commitments on issues of rights. And when those rights are threatened, we will use our resources, including the resources of having these kinds of conversations, despite the fact that it's 90 degrees outside and it's the middle of July and we're all online. We will use those resources to push forward conversation, defend the interests that we have as an institution. So I'll say again, Andy, thank you for your leadership in convening these conversations. Thank you to the guest speaker, and looking forward to the conversation. So welcome, everybody.
Thank you. Thanks very much, Vince, and thanks for partnering with us on this. So I want to introduce our three panelists. We're joined by three distinguished experts in their fields, and as I said before, really activists and leaders in their fields. First, Tico Almeida. He is currently a counsel at WilmerHale in Washington, D.C. He has previously served in senior roles on Capitol Hill and in the advocacy community in Washington. Tico was the founder and the executive director of Freedom to Work, an organization that led efforts to get Congress to consider workplace protections for LGBTQ Americans over the past decade. Second, we have Stephanie Dahlia. She's the managing attorney for CUNY Citizenship Now. Citizenship Now provides legal services to individuals and families who are on their path to US citizenship. She previously, we're happy to say, worked here at City College, and she provided and oversaw legal services and advocacy at City College, including for our Daca students. And Kathryn Kolbert is a reproductive rights attorney. She was a co-founder of the Center for Reproductive Rights, which is the leading reproductive rights legal organization in the nation. In 1992, Kolbert argued at the US Supreme Court the case Planned Parenthood versus Casey, a case that challenged 5 abortion regulations in Pennsylvania, and it's a decision that created the context for current jurisprudence around reproductive rights. We're grateful to have all three of our panelists. Just a couple of housekeeping notes. First, as you can probably see in the top left corner, we're recording this event. We're doing that with the permission of our speakers. We'll share the link with all of you afterwards, and we'll share it with those who couldn't be with us. We're going to have a conversation for approximately the next 30 to 40 minutes among our panel, and then we're going to open it up to Q&A. And I want to encourage everybody to make good use of the chat space for comments and for questions throughout the event today, starting now. My colleague Debbie Chang, who is our Director of Fellowships and Public Service Partnerships, she's going to keep an eye on the chat space, and she will moderate your questions from there when we get to the Q&A. And then last, we've muted everybody, so we can hear our guests clearly. So with that, let's begin. And I want to begin by inviting each of our speakers to introduce themselves a little more than I just did, and to say a little bit about the history of their work on the issues that were decided in the past couple of weeks, and really how we should understand what the Supreme Court did just do with these cases and how these decisions matter. So let's start. We'll take them in the order in which I introduced them, which also happened to be the order in which the cases were issued. And Tico, let me invite you to start us.
Great. Thank you, Andy, and thank you to everyone at the Colin Powell School for this very important and timely conversation. So I, as counsel at WilmerHale, worked on an amicus brief that we submitted to the Supreme Court last year on behalf of more than 200 large companies, business leaders in the US who supported the LGBTQ plaintiffs in the workplace discrimination case that went to the court in Bostock and led to a tremendous victory this June. You know, there are so many countless advocates who worked for really 4 decades to lead to this victory. And in some ways, rather than singling out, it's almost impossible to single out, you know, the folks who deserve credit. Instead, I think I'd like to single out the entity that should be embarrassed for its lack of action, leading, you know, throughout this 40-year history, and that's our broken Congress. to tell just a little bit of this story, we can begin with an esteemed graduate of City University of New York, who was the Congresswoman for Manhattan, the US Congresswoman for Manhattan, Representative Bella Abzug, who in 1974 introduced the very first gay rights workplace non-discrimination bill in Congress, in many ways ahead of her time. And unfortunately, after that very inspiring, and you might say before its time position, that is followed by 40 years of inaction and 40 years of really frustrating failure. I'll touch on just a few of those points in the history. You fast forward to 1996, and the US Senate took up a bill called the Employment Nondiscrimination Act that would have banned anti-gay discrimination in the workplace, not anti-trans discrimination, unfortunately, in that bill, which the vote counting suggested was going to be a basic tie at 50-50. And in preparation for that tie, then Vice President Al Gore was sitting on the Senate floor in September of 1996, waiting to break the tie, as the Constitution gives him the power to do, and it would have been sort of the first gay rights victory in the history of Congress. Unfortunately, one of the Democratic senators was absent, and we lost 49-50, 50 against, 49 in favor. Al Gore waiting to cast that tie-breaking vote in favor of gay rights. I think it's important to note where we were in terms of the culture. This is a vote that takes place a year before Ellen DeGeneres comes out, 2 years before the murder of Matthew Shepard, still in some ways very early in the culture war, and when in some ways, you would think that this would still be a struggle to get it passed, and we got to 50-50. You fast forward to later votes when the idea of banning workplace discrimination against LGBTQ workers is now a supermajority position. Polls have consistently for the past few decades put support for the idea at above 70%, sometimes 80%, and interestingly, even majority support among Republican voters. Just a bare majority, but in the low 50s in support of banning LGBTQ workplace discrimination with Republican voters. And even then, Congress can't pass something that is uniformly held as a position among the American people. You shouldn't get fired just because of who you are or who you love. You fast forward to 2007, and there's a vote in the US House of Representatives that unfortunately passes, but unfortunately only with sexual orientation protections, not with gender identity protections. It is deemed at that point that adding trans people to the protections that in the bill that went through Congress would have made the whole ship go down, if you will. And that leads to a lot of internal debate in the movement, internal debate in Congress. And I think in some ways it's a never again moment. We got over that hurdle, but I think a broad recognition that it was done the wrong way, it was done leaving people behind. And it actually, in some ways, I think makes really lovely and important one aspect of the Supreme Court decision just from last month. This is a case that includes the entire LGBTQ community together. It is, in fact, an amalgam of several cases in lower courts, some brought by lesbian plaintiffs, some brought by gay plaintiffs, some brought by trans plaintiffs, brought together into one case with one decision. It didn't have to be that way, and in fact, even up until a few years ago, many people would not have predicted that it was going to end up that way, but it really, in light of the history, in light of that moment of division in the community and in the movement in 2007, it is quite lovely that by 2020, it is one unified decision that grants workplace protections across the board. The next step in the legislative process is a 2013 vote where the Senate passes the bill, this time with 10 Republican senators joining all Democrats in a 62 to 30 something vote, approximately 63 might have been the count. And I think one of the notable things about that vote is how clearly uncomfortable Republican senators, even those who opposed, were about the very fact that the debate was going on. I was in the chamber in the Senate floor, not on the Senate floor, but above in the viewing area during that debate in 2013, and the floor manager for the Democrats had a certain amount of time to give out to all of the Democratic senators who wanted to support the bill and speak in favor of it. And in fact, there was an oversubscription of senators wanting to speak in favor. The Republican floor manager had a difficult time using up all of his time. And there is a moment that I remember very clearly where the Republican floor manager offered to Ted Cruz, someone who is not shy about his conservative position, offered to Ted Cruz the opportunity, will you speak against the bill? And Ted Cruz, standing on the Senate floor, shook his head no and didn't want to deal with this. So even those who oppose, I think by 2013, are quite uncomfortable with the idea that they would have to publicly speak and create sort of the public record of why they're opposed. And that, I think, leads us to a place where by 2020, we had some nice surprises in the idea that someone like Justice Gorsuch, appointed by President Trump, would be the one to write a very text-based, in some ways, in terms of jurisprudence and canons of statutory interpretation, it's a conservative opinion in that it's about relying on the text and not on Congress's intent. But in its outcome, a really wonderful progressive civil rights victory with an unlikely author at its helm. So I know that we'll get into a lot of follow-up questions after that, but I'll stop there on this history of how we've gotten to a really tremendous nationwide victory.
Great, thank you, Tico. Now let's go over to the Daca decision, and Stephanie, let me invite you to share a little bit.
Thank you. I'm so happy that I get to go after Tico because in essence, the exact same issues with Congress not acting in regards to immigration laws is exactly what is happening with this need for a decision about DACA. A lot of people say consistently our immigration laws are broken. What does that mean? Well, it means that we have laws that were written a very long time ago that were impacted by choices about the war on drugs rules that were set that had very negative impacts that I don't think any of us foresaw when it comes to immigration. And now we're still dealing with the consequences. But in addition to dealing with the consequences of decisions and rules and laws that I think at the time, while we can disagree with it now, I don't know if going back then we would have said that we disagreed then. A lot of us did, a lot of us had that foresight, but let's pretend that at the time the decisions made sense. The issue is that now it no longer does, right? Congress's failure to act puts us in a position where now we're unfortunately left with the Supreme Court making choices. So now that we have a general background, I'll give you a little bit about DACA. DACA was, and I think most of us know this, but just to kind of make sure that we set the right foundation, DACA was presented by President Obama, and in 2012, it permitted people who were under 16 at the time of entry, who came before June 15, 2012, to get permission to remain in this country without the fear of deportation, get permission to work in this country, amongst other things. And at the time, that version of DACA included permission to travel under very specific circumstances. The big thing about that is President Obama did it through something called executive action. So while it basically has the same weight as rules that were set by Congress, the difference is that any president can, with another set of executive action, get rid of it. That's important to understand because prior to the decision from the Supreme Court about DACA, everyone I know in the immigration field were terrified. We were terrified because we understood that the way the law works is that presidents do have the power to make executive actions. And in so doing, the same way President Obama could create DACA, President Trump could get rid of it. One of the things that we're incredibly grateful for is that the president didn't follow the right rules when trying to get rid of DACA. It's important to understand this because while we're celebrating this decision that was found in favor of DACA, at this point I'm going to switch over and literally read the words of the Supreme Court itself. Chief Justice Roberts, in deciding in DACA, said, "The dispute before the court is not whether DHS may rescind DACA. All parties agree that it may. The dispute instead is primarily about the procedure the agency followed in doing so." That's crucial. When you read those words, what he is in fact saying is, President can end DACA at any point. Lucky for us, he used the wrong procedure. To give you a little bit background of why we're excited about this is because we have an election in November. So what is the procedure? Well, first, he has to make an announcement. Second, he has to give 30 days for comments. Then he has to take the time to review those comments. And then when he announces the change, he has to give a certain amount of time before it goes in effect. At best, if he moves at a very fast pace, we're looking at 90 days. For us, we don't anticipate the change to take effect before a new election. And so we're celebrating it not because we are confident that Daca is being protected. We're celebrating it because we're confident that he won't be able to end it in time. I specify that because I think it puts us at an interesting time in our history where we're excited for just a little bit more time. We're excited that the wrong procedures were used because for us, it allows over 1 million people to remain in this country lawfully. Quick background of why this matters so much to me. As Andrew Rich mentioned earlier, at one point in my career with Citizenship Now, I was at City College. I was there during 2015, between 2015 and 2016, which was pivotal in Daca history. When prior to President Trump taking office, he announced specifically when he got in, he was going to try to end Daca. So in preparation for doing so, Citizenship Now basically reached out to a bunch of the colleges in the CUNY system. Obviously, my base was City College. And we basically figured out ways to help people travel in time before Daca was rescinded. We're grateful that it was never officially rescinded, but one of the things that happened is, and this is why this matters, if you did not enter the country lawfully, you're prevented from getting a green card in this country. People who had Daca were able to travel under specific circumstances. And so for a lot of people, the ability to travel would be the difference between getting a green card in this country and either having a very difficult waiver or having to return to your home country. Our organization, I think we helped over 27 people, Daca recipients, change their status, travel, enter lawfully, basically with advanced parole. And that kind of put us in a position where I think a lot of people in the Daca community and Daca recipients started reaching out to us for assistance. This matters a lot because I think while this decision was happening, my organization and my attorneys were just as stressed as a lot of the recipients. I think we've been under so much attack since this office, and by we, I mean the immigration community. Both immigrants, immigration lawyers, immigration advocates, which include a lot of you, are constantly stressed about what's coming next. And so when talking about these Supreme Court decisions, I think it's important to really understand the details of where we are, right? First, yes, technically it's a win, but it's a very technical win, right? It's not an actual win. On that note, I'm going to pass it on back to Andy in the hopes that the next person can have a brighter end than I did.
Thank you, Stephanie. Okay, well, let me turn it over to Kitty to talk to us about the reproductive rights case.
So thank you, Dean Rich, President Boudreau, all of you who have joined us today. I really appreciate your attention and interest in these issues. It's been a very, very interesting term of the Supreme Court. There were 2 cases affecting reproductive rights that the court decided. One we won, and one, meaning the pro-choice side, won, and one we lost. And both of them affect how this issue will be adjudicated going forward. Let me take the Jew medical case versus Russo first. It was a challenge to a Louisiana law that required doctors who perform abortions to get admitting privileges in local hospitals. And frankly, the entire intent of the law was to make it more difficult for women to obtain abortions, affecting low-income women, primarily women of color, and women who lived in rural areas the most by interfering with their ability to obtain abortions. Now, the interesting part of this case was that the exact same law was challenged 4 years ago in a Texas case. And at that time, the Supreme Court, prior to the addition of 2 conservative justices, 5 members of the Supreme Court struck down that law as a violation of the Constitution. And so the question in Louisiana was, is the court going to treat abortion the same way they did only 4 years ago? Or are they going to modify the standard? Now, when I say the standard, that means in legal speak, primarily how you win or lose a particular case. Under Roe versus Wade, the standard gave women the highest level of constitutional protection. That's known as strict scrutiny. Under Planned Parenthood versus Casey, which was my case in 1992, the court changed that and gave states greater deference or greater ability to restrict women's rights and created what has been known as the undue burden standard. But even under the undue burden standard, some state restrictions, not all of them, but some were unconstitutional, and the doctor admitting privileges was one of those. So the court was then, in this particular case, had to address whether or not they were going to follow the old law or adopt a new standard that would either find this law constitutional under Casey or give states much, much greater latitude to restrict abortion and allow them, in fact, to ban all abortions by adopting an even more permissive standard. So here's what the court did. The four liberal justices, written by Justice Breyer and joined by the three women on the court, found that the Texas law was unconstitutional under the undue burden standard. Chief Justice Roberts joined the result of that opinion, but wrote separately, basically saying that while he had joined the majority, or had joined the dissenters in the Texas case, he thinks these laws should be permitted. He was, on the other hand, going to adopt what lawyers call stare decisis, or the principle in law that you follow a previous opinion. And therefore, the chief, in effect, adopted or upheld the Texas standard. Four other justices, in two other opinions, basically dissented and took the view that not only was the Texas decision and the Louisiana decision wrong, but states should have the ability not only to enact these kinds of restrictions, but to enact a whole host of others that will interfere with women's ability to make reproductive choices. So the question is, why was this so important? Let me just say, all three of these decisions we're talking about today were a surprise. To me, the LGBTQ case was the most important. It was a decision that is landmark in its breadth and reach. It is a decision that affects millions of Americans and was frankly very, very surprising that Gorsuch would write that opinion. But it applied, as Justice Kagan said, I guess we're all now textualists, meaning even liberal justices. And that's what happened in that case. That's the landmark case. Both the Daca case and the abortion case are temporary holds. And I think they were decided by the chief in the abortion case because he did not want to be in a position of finding abortion unconstitutional prior to the 2020 elections and wanted to, again, reemphasize that the principles of stare decisis, the principles that the rule of law controls, remain a central part of his legacy in the court. And I think his decision was totally based on this view that he, as the chief, is responsible for upholding the institutional integrity of the court, that the old rules still apply in some small regard, and that stare decisis is an important factor. Two more things I want to add, and then I'm going to let us go to conversation because that's always more interesting. But the first is the chief's opinion, based on stare decisis, does not make him a liberal. He is now at the center of the court, but that does not mean that he has become further to the left. It only means that the court has moved to the right and his positions are now central. But the court is still very, very conservative. And it seems to me that there will be a number of opportunities for this court following the election to further restrict abortion rights, to further restrict women's rights, to further restrict, DACA or other effects on women and LGBT Americans. So I think that we have to look closely at what the chief does, but we shouldn't be swayed by the view that he woke up and became a liberal. The second thing I want to say is that the contraceptive coverage case that was also decided this term was an extremely significant decision that has an opportunity to undermine both the LGBTQ case and abortion rights. Because what the court did is it said that the case involved contraceptive coverage, mandated contraception under the Affordable Care Act. The Catholic Church and a variety of Catholic institutions challenged the exemption for religious institutions, said it wasn't broad enough. And the court said, yes, you're right, it wasn't broad enough. In fact, any institution that is run by a church, whether it be a church-based university, whether it be a church-based hospital, and remember, 50% of the hospitals in America are church-based. So any of those institutions fall within the exemption and can limit contraceptive coverage. And what that basically means is the court has just blown a hole in our notion about what's religious liberty, has expanded religious liberty to such an extent that any church in any capacity can really use that exemption to any civil rights law, whether it be mandated coverage under the Affordable Care Act, or whether it be Title VII or Title IX or any of the other protections that we have. In my view, it's an extremely damaging opinion, could be very problematic for what we think of as civil rights protections, because now huge aspects of church-based institutions may well be exempt from those restrictions. And I'm going to leave it there, and I'd love to talk more.
Well, can I actually ask you, Kitty, to pick up on that just a little more, because how big a hole does that blow in the decisions that we're otherwise celebrating? I mean, where would you kind of be keeping an eye if you're worried about what was just made possible by these decisions?
So I think it blows a very large hole. We knew in Hobby Lobby that the court had given great deference to religious corporations. But that hole is a lot smaller because very few, at least publicly large corporations, very few small corporations want to be on record as being against gay and lesbian rights or being against women. On the other hand, the churches, particularly the conservative churches, don't have that same problem. So about 70,000 to 126,000 employees of church-based institutions no longer have to provide mandated contraception. Under this particular ruling, and I think it could be very, very broad as a chip away of any civil rights protections. Because basically the question becomes, do you have a statutory civil rights protection or a constitutionally based civil rights protection balanced against a free freedom of religion constitutional protection? In any case, what the court is saying is that the constitutional protection for freedom of religion is very broad, and that they are going to use it to undermine all kinds of civil rights protections.
So I'd like to ask each of you to say a bit about then where these decisions leave the area that you've spoken to, kind of what is settled in law in a sense, and what venue should we be looking to for whatever the next chapter in the fight might be? I mean, in other words, is this an issue that's going to continue to play out in the courts, or as I think both Stephanie and Tico suggested, we should keep an eye as well on either who gets elected president or what kind of activity happens over in Congress. So let me start, Tico, because as Kitty says, the LGBTQ rights decision was the landmark decision. But when you gave us the history, but tell us a little bit about what its implications are and where we're headed.
Right. Thanks, Andy. It certainly was landmark, and it creates or reinforces workplace protections for millions of Americans, across the United States, and in particular in southern states and in plain states where state legislatures had not passed the equivalent state law, leaving workers completely vulnerable to getting fired for being trans, for being bisexual, for getting married to someone of the same sex. And so in the South and in the Plains, it means real concrete protections that were not definitively there and that are there now. It's important to note that the three cases combined that went before the court and that led to this victory are all in the workplace context and brought under the Title VII workplace civil rights statute. But the logic of the court that when Congress in 1964 used the word the phrase because of sex, and because of sex now includes sexual orientation and gender identity, that logic very likely means that every other federal civil rights statute that uses the same phrase or that protects based on sex discrimination can now, through what you would think is a relatively easy litigation going forward, be held to include LGBTQ people in that protection. So the Fair Housing Act, basically all of the other areas of federal civil rights law that include sex, but here is a key gap. Our civil rights statutes, federal, do not include sex-based protections in public accommodations. That has been the case for 50 years. Congress simply left it out in 1964. And so just as women have not been able to bring a federal public accommodations lawsuit for the past 50 years, today, under the logic of Bostock, LGBTQ plaintiffs cannot bring a public accommodations lawsuit. So that means being denied access to retail, for example, the cake baker, and that is a particular set of facts that has gone before the court, but you can think of sort of ones less connected to religion, and it is the case under federal civil rights law that someone, without the artistic angle of the cake baker's facts, could simply just close their store doors or their restaurant doors or their hotel doors to a same-sex couple who wanted to stay at a bed and breakfast, for example. And so this is an area where the LGBT bill that has been introduced even prior to the Supreme Court's decision, which is called the Equality Act, and which passed the House last year under the new Democratic majority, it actually does something to reinforce what we've won from the Supreme Court, which is making it super abundantly clear that LGBTQ people are included in the civil rights laws, but it does something that's even broader and goes beyond LGBT civil rights and to include sort of everyone. It broadens who's covered under public accommodations so that sex would, for the first time, be there as well and offer new litigation strategies and new civil rights strategies for movements beyond LGBT civil rights.
Stephanie, what about with DACA?
Yeah, so unlike the LGBTQ case, DACA is the polar opposite. It is not a landmark case. If anything, it's a Band-Aid. The Supreme Court made sure to say in their decision that they are finding that the manner in which this administration chose to attempt to end DACA was flawed, but their ability or their right to their legal authority to end DACA is valid. That matters for us because the reason we needed DACA to begin with is because Congress didn't act, right? There are many people in this country who are undocumented and do not have a path to documentation. What does that mean? There are laws in our country that if you enter unlawfully, or if you enter lawfully even, and you stay here a certain amount of time beyond the time you're permitted to, even if you have a family member, unless they fit a very specific category, that family member won't be able to give you a green card. The asylum rules are very restrictive, and they've become even more restrictive recently. But in essence, you basically have the path to asylum within a year, and really your country has to, you have to have some kind of fear of death or prosecution going back home, if you go back home, right? Alternatively, you could possibly get a green card perhaps through an employer, but even that has become more competitive and more restrictive. And so for a lot of people, there is basically no path to a green card. A green card is lawful permanent residence, which is the thing that gives people an ultimate path to citizenship. And so what we have are millions of people who are undocumented, who do not have a path to lawful status. Congress is not acting, right? They're not creating a path. The DREAM Act came close. We were excited. We thought it was going to pass through, made it past the Senate, and then failed. So that would have given a path to citizenship to a lot of the people that ended up getting temporary lawful status or it's not actual lawful status if you have DACA. Really, you're permitted to remain here for 2 years at a time. You have to continue to pay to renew it. So I hate to refer to it as lawful status, but it's basically temporary status. But the reason for DACA was because one, the the Congress did not act in creating rules. And the president then had to basically create something that allowed some people to stay here lawfully. The fact that this thing that the ex-president created, President Obama, is now something that the Supreme Court has said flat out, this administration doesn't have to uphold, and that there's no security in it. It means that those millions of people are still, unfortunately, they're in a space where they have no security, right? They don't have a security regarding whether or not they're going to be able to remain here for much longer. They don't know when this administration may act. We don't know who will win the next election. And so we don't know, and who wins the next election will have a huge impact regarding where we go with DACA. And so for us, we have to pay close attention to Congress. Congress is currently the only group that can actually do something, right? The Supreme Court have spoken. They have said flat out, the president has the right to end this if they want. They didn't do it the right way, so we're gonna find this was arbitrary and capricious, but if they did it the right way, we'd uphold it. The president and or the White House have made their views clear. They don't want DACA, right? And so the only group that is left to provide any kind of security for undocumented individuals is Congress. And let me just add, what we're finding during this pandemic is that coincidentally, a lot of our immigrant population happens to be our essential workers. And so I think it's an interesting time for us to be attacking this group, because they do make up a very large portion of who's working and who's delivering all the food, who is working in the stores, who are the frontline nurses. I'm an immigrant person, I'm Haitian to be specific. Nurses, being a nurse is something you're just expected to do. I happen to be a lawyer, but if I was a nurse, my parents would have been just as satisfied. But a lot of immigrant families do go into nursing, the home care health therapy, which is also a group that is going to take care of the elderly and those who are disabled. So I just kind of want to bring it back home when we're talking about these decisions from this kind of macro perspective, right? The Supreme Court is huge, and it's, you know, it's this power. It really affects the person who is delivering your food, the person who is your nurse, the person who is cleaning up, you know, the hospitals, the person who keeps the pulse of the city and country alive. So yeah, we got to focus on Congress now, because, or God willing, a different administration that is willing to at least uphold DACA and continue DACA until Congress acts, one or the other.
Thank you. And let me, so it sounds like, all right, so for DACA, we need to look to Congress, and we need to look at the presidential election. LGBTQ rights, we got to look to Congress. What about on reproductive rights, Kitty? It seems like that's not, the answer may not be the same.
Right, the answer is definitely not the same. And let me just make 3 points here very quickly. First and foremost, remember there are already 5 votes on the Supreme Court who are very conservative, who will probably in the long term not reaffirm the reproductive rights as we know it. The federal courts have been stacked with 200 conservative judges appointed by the Trump administration. So point number 1 is the federal courts are not our friend, and the election of Joe Biden as our next president will not make the federal courts our friend. And so let's get away from thinking we can just go to court and sue. That's not going to happen. The second is there are now 29 states across this country that are controlled by a trifecta of Republicans. That means the gubernatorial seats and both houses of the legislatures are controlled by Republicans. And in those 29 states, we're likely to see reapportionment efforts to keep that majority sound over the long term. Okay, for the next 10 years following the 2020 census. So that's very bad news, because 29 states can enact restrictions on abortion that, even if they have limited constitutionality, could affect the ability of women to obtain reproductive health services, could affect a whole range of other rights at the state level. And similarly, state courts in those 29 states are often controlled by Republican judges who are very, very conservative. Okay, so, and lastly, Congress is not our friend. We obviously control the House with the Democrats, but as long as the Senate is controlled by Republicans, there's not a chance in hell that any reproductive rights legislation affecting the nation as a whole will get through. And frankly, even if we have a new majority of Democrats, it's not clear to me that the most disempowered people in America, the women of color, poor women, will be written into any national protection. So the answer, the quick answer, Andy, is we've got to take back the states. The states are the locus of our power on reproductive rights. The states are our locus, excuse me, of power on a range of issues, particularly reapportionment and voting rights. Taking back the states is #1 critical. And we can do that in many states by flipping very small numbers of seats. And let me give you an example from Pennsylvania. We need to flip 9 seats in the House and 4 seats in the Senate to take back Democratic control of all 3 chambers. That we already have the governor's race. All 3 chambers of Pennsylvania could then be in Democratic control, affecting the rights, voting rights, affecting women's rights, affecting LGBTQ rights, affecting rights of immigrants. People we care about will be better protected in that scenario, and there are a whole host of other states. So the question is, what can you do? Get involved in the very tiny state legislative races all across the country. There's all kinds of national groups that allow you to do that. Your $5, when magnified by the 80 people on this call, by the thousands of pro-choice Americans, hundreds of thousands, by those of you who care about these issues, makes a huge difference in small races, and that's where you ought to be paying attention.
Thank you. Let me invite everybody who's on the call to go ahead and start sharing questions, because we're going to open it up to questions in just a minute. So share your questions over in the chat space, please. And Debbie is going to pick those up, and we will get to them in just a minute. Let me just pick up on what Kitty just said and turn to Tico in particular, because it strikes me that each of you has been talking about an issue where, at least as I understand how you've described it, a majority of Americans are in support of the view that has now been affirmed by the court to varying degrees, right? And yet, as Kitty just points out, we're in a pretty tough spot on every front: Congress, the presidency, the courts, which have now been transformed, and at the state and local levels. How did we? This is not necessarily your expertise, but I think you know quite a bit about this. How did we get to this point? How have conservatives been so effective? Why have progressive forces been at such a disadvantage, and how do we turn that around?
Great. Well, thanks. I'll volunteer 2 structural hurdles to good progressive policy. One is gerrymandering in the states, and the other is the filibuster in the US Senate. In terms of state legislatures, I completely co-sign Kitty's very important comments about how winning back states is crucially important. And I think we have a very recent example in LGBTQ rights about how exactly a flipping of state legislatures can lead to a good result. And that is, pretty much unnoticed just before the historic Supreme Court decision for gay rights and transgender rights. The state of Virginia passed LGBTQ workplace protections, and more than workplace, housing, credit, et cetera. And that's an example of a state that had been for decades in Republican hands, or in split hands, with one chamber controlled by Democrats, another chamber controlled by Republicans. And this past year or so is basically the first time in many of our living memories in which Virginia's state government is under full Democratic control. And what that has meant is that a long-stalled bill to give LGBTQ Virginians the right to work without discrimination went through, was signed by the governor, and is in fact now in effect just before the Supreme Court did the same thing. And that's a wonderful problem. It's a wonderful thing to have overlapping protections at the state level and at the federal level. And then, so, that suggests that winning more workplace protections for LGBTQ workers in Florida, in Texas, in places where it hasn't happened, is about flipping the states from red to blue. And then the other structural impediment has been the filibuster in the Senate. And, I am hopeful that there will be a Democratic majority in the Senate starting next January 20-something. But whether or not whether that Democratic majority has 51 or 52 senators or a lot more senators really matters because of the 60 vote threshold of the filibuster. And it may be the difference between passing the Equality Act or not passing the Equality Act. You know, I mentioned Ted Cruz before as having in 2013, you know, at that point being unwilling to speak out against the LGBT bill that he voted no on. But it seems to me that with the stakes higher and when this perhaps really happening, next January could be the point at which the Equality Act becomes reality. If the filibuster is still around, I suspect one of the Republicans will choose to use it. So there's sort of a decision point around the next Senate Majority Leader, whether it's the same one we have or perhaps a new Democrat, you know, becoming Senate Majority Leader, and whether that person wants to get rid of the filibuster as impacting, you know, I would guess not just on LGBT rights, but there's a question about can immigration reform happen at a 50 vote threshold or a 60 vote threshold, and is the filibuster the difference?
Stephanie, I'm wondering, I don't know if you have a perspective on this. It seems as if on the immigrant rights issues, the federal level is the level at which the decisions get made.
Yes, so yes and no. Immigration law is federal law. So as much as states want to help and support immigrants, it's unfortunately controlled by federal law, right? So Congress must act. Unlike criminal law, for instance, where states can basically act. That said, New York, for instance, is a pro-immigrant state. That matters. That matters greatly because one of the big things that happened with New York, for instance, is within the past couple of years, as this administration became more aggressive with deportations, we started to permit free defense for immigrants, right? So immigration is considered civil law, and civil law is not entitled to representation, defense, free defense from deportation, right? So if you're accused of a criminal, if you're being prosecuted for criminal activity, you're entitled to an attorney paid for by the state. If you're being deported or at risk of being deported, up until quite recently in New York, you were not entitled to any defense. We know statistically speaking, and this was by a judge, don't quote me on his name, but a judge basically found something like 80% of cases that are denied in immigration are done or denied partially because the person didn't have representation. And had they had representation, they would have been successful. As an immigration attorney with Citizenship now, I manage our city council program where we provide services for about 40 city council members. We get tons of people to come to us because of issues with cases that were improperly filed. And then we have to do the work of basically trying to fix the errors that were made. Most of those either saw notarios or attempted to do it on their own. So having representation in immigration matters greatly. So in regards to whether it matters, whether the fact that it's federally, a federal law makes a difference, it happens to make a difference because states can do things to protect immigrants from deportation or the consequences of this kind of attack, right? So one was providing free immigration defense in courts. Another is passing laws that kept ICE out of family court and housing court. Another big thing, right? If the local administration is pro-immigration or conservative, ICE has more power. They can move into more courts. So the things that the state courts have power over, they can keep ICE out of those things. They could choose not to cooperate with ICE. So it does actually make a difference whether the local government is, I guess, liberal or less conservative, or right, whichever term you want to use. But ultimately, at the very end, all immigration laws must be, unfortunately, federal. So until we can get Congress to pass laws, the laws will be as they are. And the only thing the states can do is give the undocumented individuals as much support as possible while they fight against this, right? So you give them the attorneys, you keep ICE out of housing court, you keep ICE out of family court. You don't cooperate with ICE, right? You require that the Department of Human Resources do not share information with ICE. You don't, and technically speaking, there are limited things that we cannot enforce, but the mayor made it abundantly clear that they support immigration. CUNY made it clear they support immigrants. That matters, right? It gives people confidence, but more importantly, when they're at least going to court, they have an attorney that they don't have to pay for, which is a world of a difference. So I hope that helped.
Thank you. Yeah. And Kitty, you've already commented on this, but maybe let me ask you just a variant on this, and then we're going to go to Debbie and to the audience's questions. So please keep sending them in. And that is, you started your remarks by saying, you know, these were decisions that were surprising to a lot of us, including to you. But when we planned this event, when I got excited about doing the event, I was feeling pretty good about these 3 decisions, and now you've kind of left me feeling not so good. At least around 2 of them, and frankly about the kind of direction the court is going. And I guess I wonder if you might just comment again on like what therefore should we be feeling good? Should we not be feeling good? Like kind of where are you left with this?
Well, I've always been of the view that if you want to protect our civil liberties over the long term, we need to we need to remain vigilant on all fronts for all time. So yes, we should be feeling good because, you know, in this day and age, any win is worthy of celebration, however small it may be. And we have to celebrate the wins when we get them. But in the long term, our vigilance, our attention to detail, our attention to really changing who is in power in this country is what is going to give us long-term protections. And we're not going to get them without that vigilance and without that activism and that efforts. The good news is Americans are actually angry at the craziness that's going on across this country. They are, you know, in the streets protesting. They are registering to vote at, you know, at much higher levels. They are active in our political system. That's really critical. The only 2 places I would pay attention to, in addition to ones that I've mentioned, is I think we have to pay attention to the census. For those of you who don't know, 2020 is a census year. Who signs up for the census, how we count our citizenship, or who is in the country. It's not just citizens, but whoever is in the country. How we make those counts affects not only allocations of who gets federal dollars, but affects how legislative lines are drawn at the federal level and ultimately at the state level as well. And so it is much easier to gerrymander districts when the count is wrong, and the undercount, particularly in urban areas affecting people of color, is what I'm most concerned about. So pay attention to the census, and second of all, pay attention to how we vote, the reforms we need to vote, because ultimately the ability of the right to take over the voting systems and to make it more difficult for people we care about to vote is a big, big problem.
Debbie, let me turn it over to you and you can share some questions.
Thanks, Andy. So the first question is for the 3 panelists. What are your thoughts on the ever-increasing policy-making role of the Supreme Court?
Well, I'll start by saying I don't actually think that the Supreme Court is in a policy-making role at all, nor should it be in some bigger sense. I think strict constructionism, which is kind of the way the court is moving, has the ability to be influenced by the politics of individual justices in the same way that any other interpretation of the Constitution is able to do. But historically, I don't see these particular 9 justices being any more adopting policy more than any other set of 9 justices we've seen throughout history. And, you know, in the same way as the Supreme Court upholding the New Deal and the Supreme Court creating rights around contraception and abortion and creating the rights to gay marriage, all of those by the right are accused of being policy making. I don't look at it that way. I look at it as interpreting the Constitution in a way that is protective of Americans.
Yeah, I completely agree with Kitty's take, and would make 2 points as to how the Bostock LGBTQ decision is not policymaking. One is that in the dissents, Justice Kavanaugh and others sort of listed out what they consider a parade of horribles about all kinds of possibilities, workplace scenarios in which certain people might be uncomfortable to have a transgender coworker. And, you know, Justice Gorsuch very rightfully said, those issues are not before this court today. This is not what the plaintiffs in these cases brought cases about. These are people who were actually fired. For example, in the case of Amy Stevens, she was fired after a long, successful career with her employer in which she had great, you know, reviews, in which she did great work. And it was the mere fact that she told her employer that she was going to transition that caused her to get fired. So the sort of all the policy considerations that the conservative justices wanted to impute into the decision, Justice Gorsuch did a nice job of saying that's not what this case is about. And in some ways, I think Gorsuch invites Congress, which hopefully next year takes up the Equality Act, to sort of iron out some of those policy decisions about what rules can an employer adopt or not adopt when it comes to shared bathrooms or shared facilities. And, you know, that does make me worry because, you know, there are lots of reasons to worry about Congress getting stuff like that right when they are in many ways not representative of Americans and a little bit clueless on day-to-day things. But Gorsuch did a nice job of refusing to do the policy making. And then this, you know, the second thing I'll say about that accusation that sometimes gets put against the court is it often implies that the court is way ahead of the American people or doing something that the American people aren't ready for. And I think this LGBTQ case in particular is an example where the super majority support, where even a majority of Republican voters believe in the idea, shows that this is not a court ahead of the American people. This is a court catching up to the American people.
I'll just quickly add, I think Kitty mentioned this much earlier on, that Chief Justice Roberts specifically stated, I think back in 2007, prior to the current times we were, and I don't remember which article I read it, but I remember that one of the things was that he wanted to make sure that his court followed the letter of the law, that it did not become partisan, that if anything, he wanted to minimize by-court decisions. Furthermore, I think evidence of the fact that he's not policymaking is the fact that he specifically stated the decision about whether or not DACA is lawful is up to the states. We're not even going to touch that, right? Because we've determined that that's outside of the bounds of what we're supposed to do. Instead, we're going to talk about whether or not they followed the right procedure. I think we happen to be living in such a controversial time where we're so passionate about the things we disagree on, and we're for many things on such opposite ends of the spectrum, that I think sometimes those who disagree with the decisions determine that it must be policymaking, right? Rather than saying, oh, he did actually stick to the letter of the law. He did make sure that it was constitutional. And not he, but you know, we focus sometimes more on the Chief Justice because we know that in essence, he's the leader, right? There's a vote, but we do want, ideally, a Chief Justice that is passionate about maintaining the integrity of the courts. For immigration, it's slightly different so we are living in a time where we're seeing the injustices in our criminal justice system. Immigration has been the one point that I have been telling people during my consultations, thank God the courts keep coming through for us, right? There's been numerous attempts to negatively affect undocumented people. And the courts have repeatedly, at least in New York, have decisions that have upheld choices that allows us to basically have a little bit more freedom. And then even this one to fight further. So I think during this time, at least for immigration, not for everything, not the Supreme Court specifically, but the courts in general have kind of been the block against this administration's many attempts at taking away immigrant rights.
Thank you all for those responses. So for our next question, we have a student who wants to ask the question to the panelists. So Veritas?
Hello, everyone. My name is Salam McGee. Currently still a City College student. My question to everyone would be is this, and it's about immigration from immigrants from the Horn of Africa. What is the Congress side on COVID-19 on immigrants from the Horn of Africa?
I'll start. So
Thank you.
It's okay. Thank you for the question, by the way. So when the Ebola breakout happened, there was immediate intent to act. I have not seen the same thing happen with this pandemic. So I don't know if there's some talks happening that I'm not aware of yet, but I can say in comparison, in comparing this pandemic to the last breakout, I don't know if I would have called Ebola not necessarily a
I
pandemic.
think you should. You should.
Okay, let's go with that. So the last pandemic and this one, I think, and it might be because of who was in power, right? During the Ebola breakout, President Obama was in power, and there was this immediate need to ensure that temporary protected status was available to the people who were nationals from the countries that were affected. During coronavirus, I have seen a different, if anything, a polar opposite, different in the way it's being responded to, right? There's been this need to, not this need, but there's been an announcement that green card petitions that are consular processing aren't being approved during the pandemic, and that they're going to be on hold until further notice. There was an attempt at basically forcing F1 students to go back, well, through an announcement about not allowing F1 students to continue their status, kind of in a forced attempt to kind of either force people who are here with permission to return to their home countries during this dangerous time,
Exactly.
to open, right? So yes, I don't foresee an action regarding COVID-19. I don't know, I mean, I find out a lot of information, sadly, via tweet. And I researched the legality later. So I don't know if there will be a tweet at 2 a.m. that will say something different. I'll pass it on to the other experts on the panel.
Oh, can I just add one thing, if you don't mind?
Yeah.
It's just, the thing is, I have family from the Horn of Africa, and I have family in Canada, and it's difficult right now in COVID-19 season. And I'm trying to figure out, would this impair my education? Because I don't want it to affect my progress in City College. So that's why I asked the question, would COVID-19 affect the immigrants of Horn of Africa?
So it does. I think that I can answer it two separate ways, right? COVID-19 have created what we call a circumstance. So to the extent your lawful status expires and you need to extend it, there are rules that allow you to request an extension of stay based on emergency circumstances. CUNY is incredibly supportive of its immigrant students, thank goodness. I'm a proud member of the CUNY community. So you have all the support you're gonna need, right? If you contact me, and my email will be shared somehow. But Citizenship Now is definitely another, so we independently are pro CUNY students. So if you're a student and you're concerned about what to do, speak to attorneys. There's tons of us here to help you. CUNY itself has got your back. The chancellor has come out. I personally have met and interacted with Vince Boudreau as an immigration advocate and as an immigration attorney. He is the ideal. Like, you're like, oh, hallelujah, right? He cares passionately. And I could say that from personal experience. He wants to protect all his students, including the immigrant population. And he's on the front lines about it. And he's not the only one. So if you're an immigrant student and you're nervous, take a deep breath, we've got your back. On a broader question regarding what this administration is going to do regarding COVID-19 to protect people that are from certain African countries, I don't have any positive words to say about it, so I'll say nothing at all. And on that note, I'll pass it over to everyone else to see if they have more insight or different insight.
Maybe in the interest of time, we can skip to another question. So there are a couple more questions in the chat that are on immigration that we don't have time to get to, unfortunately. But hopefully for Ellen and for Norma, who asked these quite detailed questions, you can get in touch with Stephanie and ask her separately about your inquiries. But for the rest, for the whole panel, we have one last question. So since we've already discussed a bit of the importance of state politics, could our panelists comment on the roles that our universities can and should play on questions of expanding rights and protections for everyone?
I'm going to sit this one out and allow the other panelists to talk.
Yeah, I was going to say, I think universities play a huge role, not only as the educators of the next generation of activists that are coming through our world and making a difference in their lives and giving them the resources and the strength to fight for what we all believe in. and the faculty who have, contributing to the intellectual growth of our nation and understanding of how our nation works, but as large institutions in communities. American education today is really a huge, think about all those liberal arts colleges in small towns that are the dominant employers in those towns, or in universities in the New York City area, or in Philadelphia, or in Los Angeles that have collectively are some of the largest employers and some of the people who have greatest political clout within those communities. And it seems to me it's really, really important for them to collectively exercise that clout, not only on behalf of higher education, but frankly, in my view, on behalf of all education, because what we've seen, and I want to pick up on what Stephanie said, the pandemic has become an excuse to roll back rights in a whole range of areas, and we're not paying attention to a lot of them. And I think we need to start doing so in a much greater detail. Watch what the federal government is doing, not what they're saying they're doing, because all kinds of rollbacks are happening without us knowing much about it. And frankly, education is the one area that's being affected the greatest. So I would say our higher educational institutions, the CUNYs of the world, coupled with their fellow educators, can make a huge difference, not only for colleges and universities, but for education as a whole.
I agree with Kitty, and to underscore it, we should note that universities are large employers of, across the country of hundreds of thousands of people, and they should be good employers, and they should recognize, the workplace protections that their LGBTQ employees have and that all their employees have. And I think they should think about certain populations that are more vulnerable to workplace discrimination or to discrimination writ large. Think about and recognize the fact that trans women of color in particular are uniquely vulnerable to workplace discrimination, to violence outside of the workplace, and unfortunately violence within the workplace, and to do trainings for all employees to prevent it, and to do swift action, to correct problems when they arise and to hold people accountable when those problems arise.
Thank you very much. And I feel like that's a good note to end on, because I just want to say this. We're having this conversation, as President Boudreau said, because as an institution, we're not neutral on these questions. We care about the project of making social progress. And I think this institution, City College, is as invested as any I can think of in the country in protecting its students and, more importantly, advancing the cause of its students and of our population in meaningful and important ways. So thank you all for being a part of this conversation. Huge thanks to Tico, to Stephanie, and to Kitty for such an informed and broad-ranging conversation. Somewhat optimistic, not altogether optimistic, but certainly one that gives us reason to realize we all have to be out there and take part in our politics and in the processes of our society. So thank you all very much. Have a good afternoon, and we'll see you soon. Take care.